Our next speaker is John Mitchell from Thompson Hine in Cleveland. As an experienced trial attorney, John has defended companies and individuals in criminal, administrative, and civil trials in state and federal courts throughout the United States. John has approximately 50 jury trials and dozens of bench trials under his belt. John also has extensive first-chair trial experience defending individuals facing significant criminal exposure from alleged violations of federal and state law. His criminal practice consists of traditional white-collar criminal matters, internal corporate investigations, environmental crimes, grand jury investigations, and related administrative proceedings. With a comprehensive understanding of federal and state criminal laws, he also counsels public and privately held corporations and individuals facing unwelcome governmental scrutiny. Today, John is going to be speaking. Are we covered on this? John Mitchell has the answers. John?
Thank you. Thank you for the kind introduction, Larry. Though I would admit this is the first time I've ever given any presentation under what appears to be the displeased face of Justice Ginsburg up there in the painting. Today I'm going to talk about insurance coverage and how it fits into governmental investigations and enforcement proceedings launched by the federal and state governments. And I don't think I'm going to tell you anything today that is particularly new or revolutionary, but hopefully with kind of reviewing some stuff and some blocking and tackling that we've all engaged in the past, it will prepare us for when those times that we find ourselves looking at adverse or unwelcome governmental scrutiny. I want to start with the general idea that many of us have been in the position where we hear from the SEC or the FBI or the IRS or one of those many governmental agencies, and they contact our company, and there may be a criminal investigation or some sort of civil inquiry, and it's readily clear that the government not only wants documents and information from the company, but that it's going to involve our employees, potentially our board of directors, and others. And how do you deal with that situation when you start to sit down and you take a long and careful look at your litigation budget and you realize that the company is going to need its own attorney, the board may need its own attorney, each individual who is a target or a subject of the government's inquiries may need their own attorney, and the employees may need pool counsel to shepherd them through the process as they are witnesses in this action. Now, right away, that everybody's, the hair on the back of your head should go up because you realize that is at minimum going to be very, very, very expensive. And that's when most of us sit down and take a look at our insurance policies and kind of figure out, gee, are we covered for this? And like I said earlier, there's not a lot I'm going to be talking about that's new or even innovative, but today we're going to try to learn from the headaches that others have encountered and see if we can maybe proactively address some of the problems we could see in the future. So let's start with the critical policy definitions. Claim. Well, you know, that's an important definition, right? But it's the context in which it's applied that may make all the difference, because informal and formal investigations, as you see at the bottom, are readily encompassed in this term, and the definition and the way that this term is applied within your policy is going to, in large part, determine whether or not you're going to have the coverage that you think you're paying for. You can see that there are broad and narrow definitions used of this term, you know, and looking at the broad definition, it jumps right out at you at the beginning. Claim. A formal or informal administrative or regulatory proceeding or inquiry commenced by the following ... And it says formal and informal investigative order, which means that incidents and activities and indictments are not necessary in order for the claim definition to provide coverage. In contrast, you look at a narrow definition, and looking at the first bullet point, a written demand for monetary, non-monetary, or injunctive relief. A written demand, and you'll see as the case law we talk about later really turns on that phrase. Another critical policy definition, investigation. What is the investigation? Well, those of us who do white-collar work know that many times the lion's share of the work is done before any information or indictment is returned. The vast amount of investigation, working with the witnesses, navigating your client, the company, or the individual through the criminal justice system takes place long before any formal document is filed in court. And you see the broad definition. Looking at the first bullet point again, investigation, any investigation by an enforcement authority after any of the following has occurred. And I point to a little later where it indicates a formal or informal inquiry by a governmental investigation. In contrast, the narrow definition, once the insured person is identified by writing by an enforcement body as a target of an investigation that may lead to criminal, civil, etc. So again, it's understanding the terms that are in your policy. The very basic blocking and tackling, in large part, is going to determine, are you covered for this? Last critical policy definition, we're going to talk about loss. And this is the one that really, frankly, may be the tail wagging the dog, because when you have a broad coverage, and I'm not going to go through all of it, but you'll see it means damages, settlements, judgments, including pre, post-judgment interest, defense costs, crisis loss, derivative investigation costs. Those are all broad components that can take place before an information or an indictment has ever taken place. The narrow definition is different. Any amount legally obligated to pay. And it talks about what it shall not include: punitive or exemplary damages, civil or criminal fines or penalties, taxes. And you don't see anything in there about defense costs, which really is where the expense is in navigating through these issues. So let's talk about some of the cases here. And, you know, it really is learning from the headaches of others, because in addition to determining whether or not you have coverage for your particular incident, you know, you're going to have to go through the trouble of having to litigate this against your insurer as you're trying to obtain coverage. And the time in which you're trying to obtain coverage, as you'll see, does in fact matter as well. So we've got the Agilis case here. It's a D&O policy that covered Agilis and its officers, and the IRS issues a search warrant and subpoena to investigate a potential tax evasion scheme. And there are two subparts that really turned in this case. Subpart 1 involved a claim as a written demand for monetary or non-monetary relief, whereas subpart 3 was really focused on whether or not a criminal proceeding had been commenced by the return of an indictment. Now you can imagine which side the parties are arguing already. You know, the insurance company is saying, we don't see any indictment here. And Agilis is saying, wait a minute, warrants and subpoenas equal written demands, and therefore there is coverage. And the court agreed with them. And they said, listen, there are two possible interpretations of this policy, and in those situations we're going to err on the side of the insured. And a warrant and subpoena is necessary to constitute a claim, because it can be a demand for relief. And since relief wasn't defined in the policy, it was viewed to be very broad, and providing documents in response to a subpoena was, again, a demand for relief, and provided coverage under this situation. And interesting, the professional services exclusion didn't apply, and the criminal policy protection that everyone assumed would apply didn't apply either. The Richardson case has an executive risk insurance policy, and the Department of Justice launches a antitrust investigation that ultimately resulted in the company paying about a $500,000 fine. Again, the term claim is not denied, but under Illinois, it was held to be a demand for something that is due or believed to be due, and the insurer refused to cover the defense costs, saying, hey, look, there's no claim, because a claim must involve a demand for money. The court disagreed, said, nope, documents, information, if they're due, then there is a claim. One that applies here, the Kozlowski case. Dennis Kozlowski of Tyco fame, he's the guy who you may recall had the $20,000 shower curtain. There is an executive protection policy, and the Department of Justice had civil and criminal proceedings against Kozlowski for his mismanagement of assets when he was running Tyco. And importantly, the policy included an exclusion that if the covered executive used any of this for his personal profit, then, well, there would be an exclusion under that policy. But this was really kind of a Pyrrhic victory for the insurance company, because they litigated this issue. And the interesting part is that the policy had a provision that required the insurance company to pay for defense costs associated with the inquiry, in contrast to a duty to defend. And the interesting thing about that, the court said, you know what? Since you have an obligation to pay defense costs, you have an obligation to pay those defense costs as they are incurred. And you can retain a reservation of rights, and you can seek recoupment after all these funds have been expended, but you're going to be paying the insurance costs, or you're going to be paying the defense costs as they're accrued. So the point being that the insurance company is left in the unenviable position of trying to seek recovery from Kozlowski after it's already fronted the cost of the defense. So going back to our state, our blocking and tackling and understanding what our policies provide really makes all the difference. The Diamond Glass case, it's an interesting one because this is the other side of the coin. This is where coverage has been denied. And Diamond sought coverage relating to an ongoing grand jury investigation, a series of subpoenas, and there were numerous subpoenas requesting hundreds of thousands of documents, and if any of you have been through this, you understand exactly how broad those subpoenas can be. Policy provided that a claim arising from a criminal proceeding required an indictment, filing a notice of charge or similar document. And interestingly, because Diamond had received the subpoenas and everything else associated that allowed the government to build the case against Diamond, it was not until that required document arrived, which really is the worst day of everybody's life when that happens, that the policy was going to take effect. And because they hadn't received the indictment, seen a filing, a notice of charge, or any similar document, at that point in time, coverage was not invoked, and the court found the absence of a claim. Interestingly, under the criminal provision, and this is the flip side of the Texas law we saw earlier in the Agilis car case, that the court found that the subpoena or grand jury testimony didn't qualify as relief, which frankly is the contrary holding to what we saw in the Texas case earlier in my presentation. And there was also a provision that said, if any of the executives have been identified as a target letter, which really is a cold day when that target letter arrives from the Department of Justice informing you that you need to go find a lawyer because they're looking at you for a slew of violations. Because none of the Diamond executives had received that target letter and it wasn't pled in the complaint, well, guess what? No coverage under that as well. And the Chang case here is interesting as well. The Changs, and this can show you that maybe perhaps no good deed goes unpunished. They operated a dry cleaning business in San Francisco. There was a U.S. EPA investigation of contamination of that particular site. The Changs enter into an agreement with the insurance company that the company is going to cover certain portions of that, the cost of remediating that site, and the company does, but then ultimately does not pay the full amount because when the case is litigated, they said, listen, you were part of an investigation, you remediated the problem, you entered into a consent decree, and that's great and that's good, but none of that constitutes a suit, as we've seen under the narrow definition of claim as required by the policy, and as such, you don't have coverage under these systems or under this policy. Here's another one. Look, if you've been involved in a grand jury investigation, you know that they can be long, they can take forever, and the subpoenas that you will receive require mountains of documents in response, and they are frankly very, very expensive. Well, in this case, the Center for Blood Research starts getting subpoenas for potential health care offenses that it may or may not have committed, and ultimately was never charged for. And in order to qualify for coverage, there was a requirement that an investigation had to have had the potential for an adjudication against the Center for Blood Research. And I would argue that, the federal government taking a long, hard look at how you do business would have that potential for an adjudication against the center, but the court disagreed and would have disagreed with me. It said no adjudication could have resulted from an investigation itself, and in seeking information through the subpoena process, that does not give rise to enough to constitute a claim under the policy, and therefore, again, the costs associated with this defense were excluded. And this is really frankly, a sad one more than anything, the Silver case, which is fairly recent because Silver was the director of the loan program through the United States Department of Energy. And through his management of that program, some of the loans that he made became controversial, and there was an investigation launched by numerous governmental agencies. So Silver does what he thinks he should do, and he steps aside. He says, I'm going to resign, I'm going to get out of here, and you guys can do the investigation and clear me. So he resigns, and he walks away. But he does so before anyone notifies the insurance company that the investigation is taking place and puts the company on notice. And the insurer moves for judgment on the pleadings saying, look, the terms of the contract are unambiguous. In order to be a covered policy, you have to be a governmental employee. And since Silver had walked away before he put the company on notice and resigned, no coverage Court agrees with the insurance company, and poor Mr. Silver's left out there all alone with no one to cover his legal fees. So where does it leave us today? You know, I had a law professor who used to say the great things about lawyers is they all seek to say something profound. The problem is they keep talking until they do. And I've never forgotten that advice, and so I'm going to kind of leave you with some things that you might want to consider. Make sure, number one, that your policies and your company are tailored to meet your particular needs and the potential headaches that could arise from the way that you do business. It is not a one-size-fits-all world in anything, particularly in insurance coverage. Secondly, take a look at these policies on an annual basis. You know, the fact of the matter is the law changes in different places, and it changes in many different jurisdictions. And sitting down annually and going through this will save you a lot of headaches and problems later on. I tell people this, early analysis is better than the all-nighter. You know, when that grand jury subpoena arrives or the FBI is at your place of business and your CEO or CFO or whomever is saying, so, you got a lawyer for me, right? You don't want, that's not the time that you want to dust off your insurance policy and say, oh, I'm not sure we do, or maybe we don't, I'm just not sure, we're going to have to. No one wants to hear that. They want to hear that there's a plan in place and that they understand what coverage is in place and that their rights are going to be protected while they navigate through this crisis. Communication with the insurer. Learn from Mr. Silver's headache. The second that this comes up and that you find out that something's going on, put your insurance company on notice so that you don't have any issues or exclusion issues later. And I throw in 5 because, you know, you just never, ever know where you're going to find coverage. And, you know, I'm sure that there's always somebody there who has the institutional knowledge of the company and knows where, frankly, the bodies are buried, for lack of a better phrase. Now's the time to get a hold of that person, dig out your policies, and make sure you can account for any potential coverage you might have. So, again, once again, under the disapproving glare of Justice Ginsburg, thank you for your time today, and have a nice day.